All right, welcome to Civil Justice Full Committee today, everyone. Madam Clerk, you go ahead and take the roll.
Representatives Beck, Bricken, Bolso, Capley, Eldridge, Gant,
Here.
Garrett, Grills,
Here.
Harris, Lamberth,
Grills.
Middleton, Parkinson, Powell, Russell, Stevens, Todd, Vice Chairman Jernigan, Chairman Farmer. Mr. Chairman, you have a quorum.
And thank you for that. Members, before we get started, anybody have any comments or any recognitions? I think I forgot every week, but this week to ask that. Seeing none. We have a calendar, have a few announcements I'd like to make to begin with. Item 1, House Bill 1346. That's Chairman Powers' bill. He's asked that to be rolled for 1 week. Is there any objection to doing that? Seeing none. House Bill 1346 rolled for a week. Moving down to item 4. I'm going to hold on that, as a matter of fact. Moving down to item 6 by House Bill 1259 by Representative Vital. I believe that's going to be requested to be rolled for a week as well. Any objection? Seeing none. House Bill 1259 rolled for a week. Item 8, House Bill 464 by Representative Slater. That's been asked to be taken off notice. Any objection? Seeing none. House Bill 464 off notice. And that's all I have from there. And members, we're just going to take a couple of members out of order. If we go ahead and move to item 19 by Representative Gant, House Bill 589. Got a motion, got a second, sir. You're probably recognized.
Thank you, Chairman and committee. This piece of legislation that I'm presenting here today came from the ad hoc committee that Speaker Sexton put together, and it concerns a lot of legislation with the Department of Children's Services, and some of the process that we went through on that committee was coming up with legislation that addressed some of the problems that we identified in that ad hoc committee. And Chairman Littleton is here with us as well today and was very instrumental in that process. And so I want to thank her and the speaker for this legislation that I'm presenting here today. And I'm going to give us a summary of it, and then I'll be glad to take any questions that members may have. Present law generally provides that all applications, certificates, records, reports, and all legal documents, petitions, and records made or information received that directly or indirectly identify a child or family receiving services from the Department of Children's Services, or that identify the person who made a report of harm, must keep confidential and not be disclosed, except if certain exceptions apply. However, present law also specifies certain circumstances when the department must release information. One such circumstance is when a law enforcement agency, grand jury, or a court requests that the records upon presentation of an appropriate court order. This bill adds to this provision that the records must be released to a district attorney general upon presentation of an appropriate court order. So this would be a new procedure that's being added into the law. And I'll be glad to answer any questions. If they're hard questions, I'll defer to Chairman Littleton. She'll be glad to take them. But otherwise, I'll be glad to answer any questions.
Very good. And thank you for that explanation. Yeah, I was able to be a part of that ad hoc committee. Chair Lady Littleton, Representative Gant did a wonderful job, worked really hard over the summer. Was here more than I really wanted to be, but learned so much. But with that explanation, and there, members have any comments or questions for our sponsor? Question's been called. Seeing no objection.
Chairman Farmer, let me just add, I neglected to mention your name as part of that committee, and you were very instrumental in passing some of this legislation and helping us with that. So thank you for your leadership as well.
Yeah, and thank you, sir. Leader Lamberth.
Mr. Chairman, just as a teaching moment there for some of our freshmen on the committee here, if you're going to brag on the chairman, it's a good thing to go ahead and start off with that, like right at the top. So, I mean, just don't take any bad advice here.
Oh, goodness. Okay. All right, members. Are we ready to vote? We ready to vote? Chair Lady Littleton, you're recognized.
I resent that he thinks you should be noticed before me.
Yeah. The Chair Lady's right. Item 19, House Bill 589. Are we ready to vote? Looks like we are. All those in favor of sending House Bill 589 to calendar rule, say aye. Aye. Opposed, say no. Ayes have it. Bill moves on. And members, if we may, I'd like to take one more bill, member out of order. Item 10, House Bill 862 by Representative Shaw. You got a motion and a second, sir, and I'm looking at an amendment 4621.
That's correct.
I've got a motion on the amendment. And second. Members, we want to go ahead and put that amendment on. Does that reroute the bill, sir?
Yes, sir. It makes bill, yes.
Any objection with doing so? Seeing none. All those in favor of adopting House Amendment 4621 to House Bill 862, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman, and thank you, members, and thank you for allowing me this little space to go through something else. This amendment does rewrite the bill, and I'm going to be like the other presenter. They can ask you or Chair Lady Littleton either one questions if they're hard questions about this bill. It comes out of the ad hoc committee, and I appreciate serving on that with you and her and other members. Of course, it requires the Department of Children's Services and DCS to provide juveniles in DCS custody and housed juveniles in detention centers, hardware, residential facilities and so forth to be provided with 7-day, 24-hour psychological behavioral services if necessary. That's what the bill does. With that, I would accept any questions you may have.
Members, heard the explanation. Any questions or comments for our sponsor? Any questions or comments? Seeing none. Are we ready to vote? Any objection? Seeing none. Looks like we're ready to vote to send House Bill 862 as amended to Finance. All those in favor say aye. Aye. Opposed, say no. Ayes have it.
Thank you, Mr. Chairman and members.
Bill moves on. Thank you, sir. That brings us back to the top of our calendar. Item 1 has been rolled. Item 2 is House Bill 606 by Chairman Hawk. You've got a motion and a second, and I'm looking at an amendment coded 6436, sir.
Thank you, Mr. Chairman, members, and that will make the bill.
Very good. Members, we want to go ahead and put that on. Very good. Sounds like we do. I've got a motion. I got a second. Any objection to vote? Seeing none, all those in favor of adopting House Amendment 6436 to House Bill 606, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're recognized.
Thank you, Mr. Chairman and members. I appreciate the work of the subcommittee that delved into this issue. In most states, including Tennessee, the actions of adoption facilitators are prohibited. However, enforcement is weak. What we're doing is trying to get at the folks who are playing both an adoptive parent and the expectant mother and facilitating that, which is illegal. We're putting some stiffer penalties in place for that. Chairman Lamberth, Leader Lamberth has been instrumental in making sure that we get those penalties accurate and fair and what they should be. In a nutshell, that's what this does, Chairman and members.
Very good. And thank you for that explanation. Members, any comments or questions for our sponsor? For Chairman Hall. Seeing none, we ready to vote? Looks like we are. Any objection to the question? Seeing none. Looks like we're ready to vote to send House Bill 606 as amended to calendar and rules.
Thank you.
All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on.
Thank you, Chairman and members.
Thank you, Mr. Chair. That brings us to item 3 with Representative Alexander. That'll be House Bill 940. And you've got a motion and a second, ma'am.
Thank you, committee.
I've got 2 amendments listed, 6208 and 6687.
6687 is one we're going with.
Does that rewrite the bill?
That does rewrite the bill.
Okay, members, we want to go ahead and get that amendment on there. I've got a motion, got a second. Any objection to vote? Seeing none. Looks like we're ready to adopt House Amendment 6687, the House Bill 940. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
What this does, committee, this approximately 1 in 15 children in the United States is exposed to domestic violence each year. And what this bill does is it allows for training, educational purposes during their continuing education for judges, 2 hours each year, total of 10 hours over 5 years, to recognize abusive qualities and characters in parents so they don't put children back in harm's way again. That's all this bill does.
Thank you for that explanation. Members, we have any questions or comments for Representative Alexander before we vote? Seeing none, we ready to vote? Chairman Grills, you're recognized.
Thank you, Mr. Chairman. I may be out of order. Ms. Alexander, would you like to introduce the guest you have with you
Oh,
today?
Yes, I'm sorry. I've introduced her in other committees, but I forgot to. This is Trinity, and Trinity is from, are you from Powell or Oak Ridge? From Powell? Okay, I think I'm from Powell. These girls are identical twins. And Representative or Chairman, Chair Lady Littleton is one of them, and they're shadowing us today. So we're honored to have them with us today. They are homeschooled, so precious ladies.
Well, I have family in Powell, so that's okay to be from Powell, just so you know. And glad to have you, both you ladies here. Really, really happy to have you. Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman. And since we've introduced her twin, Zoe is my shadow today, and if y'all could welcome her as well.
So-
Very good. That brings us back to where we were.
Sorry.
Any objection to calling the question? Seeing none. All those in favor of voting to send House Bill 940 as amended to calendar and rule, say aye. Aye. Opposed, say no. Ayes have it.
Thank you, Chairman. Thank you, committee.
Thank you. And members, that brings us to item 4. And before we get a motion in a second, House Bill 944.
Yes, Chairman, thank you. If it's the will of the committee, I'd like to roll this 1 week. We have some concerns. Someone brought up some concerns to us that we want to get some clarity from the AG's office on. So before we bring it back to you, we want to make sure it's in the right posture.
And thank you for that, Representative Alexander. I was waiting to roll that because I wanted you to have an opportunity to let the members know what was going on. We really appreciate that.
Okay.
So members,
Thank
any
you.
objection to rolling House Bill 944 to next week's calendar? Seeing none. Rolled next week.
Thank you.
You're welcome. Item 5, House Bill 630, Representative Leatherwood. You've got a motion in a second, and you've got, I'm looking at House Amendment 5586.
That is correct.
If I get a motion in a second on the amendment, members, does that make the bill, sir?
Yes, it does.
Members, we want to go ahead and get that on the bill? Looks like we do. Any objection? Seeing none, all those in favor of adopting House Amendment 5586, House Bill 630, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're properly recognized, sir.
Thank you. And I don't know if this is proper for a presenter or not, but if I could have a moment of privilege here since we introduced twins and got on the subject of twins. My oldest daughter just went public yesterday. We've been waiting to do it. She is pregnant with twins, and this will be our first grandchildren. So looking forward to being proud. Haven't decided what I'll be called yet. They keep asking me if the committee has people. Any suggestions, I'm open to them, but looking forward to being the proud grandfather or whatever of twins. So what a blessing. So thank you for that.
And congratulations, Representative Leatherwood. What we would advise, I think, as a body here, would just you put a suggestion box outside of your door, and we'll anonymously put what we think those twins need to call you.
Yeah, I've been called a lot of things over the years, so that might be more interesting than I want it to be. But back on the bill, and I do appreciate y'all's indulgence with that. The amendment does make the bill. And this amendment addresses the two legislative recommendations from the Comptroller's Office after their audit of DCS. The first of these suggestions deals with the caseload cap. Instead of being an average of 20, it would change that to a hard number that would eventually become 15 cases. That would be rolled in January 1, 2027. And the second recommendation addresses the report of non-consensual sex acts at residential DCS facilities that have not been investigated.
And thank you, Representative Leatherwood, with that explanation. Members, who have any questions or comments for Representative Leatherwood? Representative Bricken, you're recognized, sir.
Thank you. Thank you, Mr. Chairman. And I've raised this in subcommittee. Again, I don't like this legislation, not because I certainly don't want to support DCS. I just have a real hard time thinking we need to put fixed case load parameters on any department. I think they should manage it in the best practices in operations, because cases are going to be different and what they're assigned to. I just think the management of DCS should do their job, and we don't need these arbitrary case parameters set. So again, I cannot support the bill because of that. So thank you.
Thank you for those comments. Representative Leatherwood, any follow-up?
We do have caseload parameters in code now, so it's not a matter of establishing them. Legislature's already done that, but we are adjusting those to something that hopefully will become more manageable for the benefit of the children. We are also authorizing here more flexibility by allowing the commissioner to employ a programmatic support personnel, special response teams, and administrative support personnel, each of whom will not maintain a regular caseload, so that they can move to where they need to be to level out the caseload. So this also helps the department develop some more flexibility. Again, bottom line, the comptroller did an extensive, I think it's a 600-page audit. This was their recommendations, and I trust their recommendations.
Very good. And thank you for those comments. Next, Representative Rick, any follow-up there? You're
Just,
recognized, sir.
Thank you, Mr. Chairman. Again, I just think this is micromanaging a department, and that bothers me. I just think whether previous legislators we did it because they weren't managing things right, and I just doubt this is going to work either. But and I just think it's just the wrong way to go about it.
Representative Leatherwood, any follow-up? All right. Next on the list, I have Chairman Grills.
Thank you, Mr. Chairman. So just, if you don't mind, just explain in short, just real short, what are you trying to accomplish by putting these parameters on there?
Representative Leatherwood.
Better care for the children is the bottom line. And it has been difficult for DCS to reach the targets already in code, which is an average of 20. But, if you have one person with 40 and then two people with 10 each, it's hard to give the children the services they want. And so this would go from an average to a hard cap, again, starting out at 20, moving to 18, and then eventually to 15 for the caseload caps. But again, it also builds in flexibility. They've got a tough job. You never know what's going to walk in the door. Never know how many cases are going to walk in the door. Hence the flexibility of the positions I said, who can move to where they need to move to, again, provide the better services for the children.
Chairman Grills.
Okay. Thank you, Mr. Chairman. This is my final question. So it seemed to me that they had a management problem or a management issue, and they're trying to pivot to this as being part of their problem, maybe not taking full responsibility for the issues that they had. Was that fair?
Well, again, I would say this is not their recommendation based on, any of the potential thoughts you just shared there. These are the comptroller's recommendations based on doing an audit, which was not a flattering audit of them, a 600-page audit. I haven't read it all, but I've read executive summaries and skimmed through it all. So these come from the comptroller to try and resolve the issues, not from DCS.
Any follow-up, Chairman Grills? You're welcome. Representative Parkinson, you're recognized.
Thank you, Mr. Chair, and thank you, Representative Leatherwood, for bringing the bill. I'm definitely going to support this bill because additionally, and I don't know if you mentioned this or not, but additionally, these caseloads are causing employment issues also, with DCS workers. And I've been, as a matter of fact, I've been hearing from DCS workers for the last, honestly, 6 years about how bad it is and how high the turnover rate is for these employees because they just cannot do it. They cannot get it done. And it's an unachievable, it's almost unachievable to hit the success and provide the services that's expected or that's needed for these children and these families, because of the caseload, and it's causing irreparable harm, with these children and with these families because they just don't have the bandwidth to get it all done. And so I appreciate you bringing the legislation. It's absolutely needed. And thanks again. I'll be supporting.
Any thoughts?
Thank you, and you're absolutely right. Again, doing an average, it's just not working. DCS has an incredibly difficult job, and this will hopefully address the retaining employees as well as hiring new employees. So I appreciate your comments.
Very good. No, well, I do have just a couple of members on the list here, just real quick. Let me hit Chairman Todd, if you don't mind.
Thank you, Mr. Chairman. And just one question. I understood that the department actually requested this legislation and wanted it. Can you just confirm that, please?
As I understand, I don't know if anyone's here that could comment on that, but they are in favor of this, as I understand.
Very good. And then last on the list, I have Representative Bolso.
Thank you, Mr. Chairman. Sponsor, my question regards the fiscal note on Amendment 5586. It's interesting in that the fiscal note indicates that the cost of the legislation is $1 million in fiscal year 24, $6.5 million in 25, $13 million in fiscal year 26, and then $28 million in fiscal year 27. My question simply is, are you able to tell us why it is that the fiscal note for each year escalates in the manner that it does?
Yes, we are reducing the caseloads. Again, going from an average of 20 to a hard cap of 20 in January 1, 2025, then reducing that to 18 in 2026, and in January 2027, reaching the goal of 15 cases. So when you have fewer cases per case worker, it takes more case workers to do that, which takes more money.
Very good. Anything else, Representative Bolso?
No, thank you, Mr. Speaker. Thank you, sponsor.
And thank you. Back to Representative Gant, sir. Question's been called. Any objection to the question? Seeing none, looks like we're ready to vote to send House Bill 630 as amended to Finance. All those in favor say aye. Aye. Opposed, say no. No. Ayes have it. Bill moves
Thank
on.
you.
That brings us to item 7, House Bill 746 by Representative Barrett. Sir, you got a motion in a second.
Thank you, Mr. Chairman. We had a really good conversation about this bill in subcommittee, and since that time, I've had an opportunity to start having conversations with Chamber of Commerce and Safety and others that are involved with shareholders that would be affected by this bill, along with my Senate sponsor. So if it's okay with the chairman, I'd like to roll this to the first calendar of 24 to give me the summer to be able to work with those shareholders and make sure that we come out on the other side with a good bill that everybody's comfortable with.
Okay. Members, any objection to rolling House Bill 746 to the first calendar of 2024? Seeing none. All in favor, say aye. Aye. Opposed, say no. Ayes have it.
Thank you, Chairman and committee.
Brings us to item 9, House Bill 164, Representative Butler. So you got a motion and a second, and I see a House Amendment 5675 on there.
Thank you, Chairman. Yes, sir. That is the amendment number.
Okay. Members, he's got House Amendment 5675 on there. Got a motion, second. Does that amendment rewrite the bill?
Not completely, but it takes out section 1 of the original bill, and for all intents and purposes, let's just say it does.
It does, and I
It-
believe it does. Members, we'll go ahead and get that amendment on there so we can move forward. Got a motion. Do I have a second? Very good. Any objection to vote? Seeing none, looks like we're ready to vote to adopt House Amendment 5675 to House Bill 164. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Chairman. If you've paid attention to the news lately, there has been several news reports of these safe haven locations. I think they just opened one in Knoxville at one of the fire stations there on Western Avenue. There's been a couple of news articles in Indiana and Kentucky where children have been dropped off just a few days after these baby boxes or safe haven boxes have been installed. So there is a tremendous need for this. So what this bill does is simplifies the process for those children to be adopted. So a brief rundown of the safe haven law, if you're not familiar with it, provides the ability for a mother to drop off her child. And as long as that child is not harmed, she has the ability to return and retrieve that child, no questions asked, as long as the child is unharmed. Based on the numbers that we've gathered from DCS and so forth, 94% of the time, the mother never returns. So what this legislation does is tries to streamline the process to allow for the adoption process to be completed after the 90 days, which is required in statute to terminate both the mother and the father's rights if they're even known who they are. And then it further requires a court to hear these adoption and abandonment cases within a set period of time, so they're not being drug out for 6 or 8 months. So essentially, if you work the calendar, a child could be abandoned, and within about 100 days, depending on a couple of little variables, would be adoptable within 100 days. So we've streamlined the process because there's been instances, I've talked to some adoption attorneys, where it has taken 20 months to get this process done. So I don't know a greater purpose that we can serve as a legislative body than to streamline the process to move children into stable homes quicker than with this type of legislation right here. And with that, I'll answer any questions and renew my motion.
Very good. Thank you for the explanation. Members, any questions or comments for our sponsor? Seeing none, we ready to vote? We're not. Representative Parkinson, you're recognized.
Thank you, Mr. Chair. I just have a quick question. So when these babies are abandoned, do they go into DCS custody immediately? What happens?
Representative Butler.
Yes, DCS is contacted. They're required to take them to a hospital to be checked out to make sure that they don't have any issues. And then DCS assumes the custody and then takes it from there.
Representative Parkinson.
Thank you, Mr. Chair, and thank you for this legislation. We definitely need to streamline the process if that's the case.
Members, any additional questions for our sponsor? Any additional questions? Seeing none, we're ready to vote? Looks like we are. Without objection, all those in favor of sending House Bill 164 as amended to calendar and rules, say aye. Aye. Opposed, say no. Ayes have it. Bill moves on.
Thank you, committee.
Thank you, sir. Brings us to item 11, House Bill 820. Representative Chisholm, yeah, I saw him. He was in here earlier, I think. Sure. Mr. Litter, you're recognized.
Mr. Chairman, just a question. If someone wants to check with him, I noticed this was gen subbed in the Senate. I don't know if somebody wants to check on him, whether or not he wants to take it off notice or not, but he was in here earlier. He may have assumed it was taken off notice, but I just want to make a recommendation if somebody wanted to reach out to him. Trying real hard not to look at Representative Parkinson right now.
Sounds good. We can roll him. Members want to roll him to the hill or a few spaces? Okay, members, let's, without objection, let's roll House Bill 820, 3 spaces. 3 spaces. That brings us to item 12, House Bill 1162 by Chairman Todd. And you got a motion and a second. I'm looking at amendment coded 6035.
That's correct, sir.
Second.
You got a motion and a second. Members, we want to go ahead and adopt that? Looks like we do. All those in favor of adopting House Amendment 6035 to House Bill 1162, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and Chairman, you're recognized.
Thank you, Mr. Chairman. This bill updates and changes arbitration procedures to meet modern needs, addressing numerous procedural issues not included in the original act. And I'll be glad to answer any specific questions if I can.
Very good. Members, Representative Garrett, you're recognized.
Thank you, Mr. Chairman. Chairman Todd, I just want to make sure there's nothing in this that compels a party to participate in arbitration. It's by agreement. Would that be an accurate
Mr. Chairman?
statement?
Thank you, Mr. Chairman. That is correct.
Okay. Thank you very much. That's all I needed.
Very good. Any other questions or comments for our sponsor? Are we ready to vote? Looks like we are. Seeing no objection. Voting to send House Bill 1162 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on to calendar and rules. Brings us to item 13, House Bill 563 by Chairman Todd. Got a motion, got a second, and I'm not seeing any amendments, sir. So you're probably recognized.
Thank you so much, Mr. Chairman. Current law says that county mayors, county clerks, members of the county legislative body, or municipal mayor cannot accept any kind of payment for solemnizing marriages, but they can accept gratuities. One problem we have with that law is that we've discovered that there is no penalty for that. It's a violation, but there's no penalty associated with it. So this brings it in line with a lot of other laws that we have that actually puts a penalty on it and keeps it as being an unlawful act. But it amends this statute to clarify that they cannot continue, they can continue solemnizing marriages only for gratuity, not for a charge. And it creates a Class C misdemeanor criminal penalty for knowing violation, for a knowing violation, and a rebuttal presumption that the violation creates an actionable basis for civil removal proceedings.
And thank you for that explanation. First, most I have Representative Powell, excuse me. Apologize for the
That's all right. We get confused a lot.
pronunciation there. Yeah, I think so.
We look alike. I appreciate this bill. We had an issue with this in Davidson County. Actually, my predecessor's predecessor was a county official and got in some trouble for this. I think it's important, to have this and make sure there is a penalty. I wish we also applied this to other officials, but I know we'll take this first step. But thank you for the bill. I think it's important, and hopefully, we won't see this abuse. But if we do, people will be duly penalized. Thank you.
Very good. Thank you for those comments, Representative Powell. Members, any additional questions or comments for our sponsor? Seeing none, question's been called. Any objection? Seeing none, looks like we're ready to vote to send House Bill 563 to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Calendar and rules it goes. That brings us to item 14, House Bill 760. So without objection, we're gonna roll that for 1 week. Without objection. House Bill 760, next week's calendar. Also brings us to item 15, same posture, members. House Bill 1044, we're going to roll that for 1 week as well. I see any objection? Seeing none. House Bill 1044, next week's calendar. That brings us to item 11, House Bill 820, back to item 11, House Bill 820 by Representative Chisholm. You got a motion, you got a second, sir?
Thank you, Chairman of the Committee. This is a House Bill 820, and what this bill does, it allows the overpayment of child support to go towards future payments until that payment is overpayment is exhausted. But seeing the posture in the Senate, we want to get that chamber to catch up with us here in the House. So I'd like to roll this bill for 1 week to get them to speed up a little bit.
Okay. Members, any objection to that request? Seeing none, looks like House Bill 820 will be placed on next week's calendar.
Thank you,
Without
Chair and
objection.
Committee.
Thank you. All right, that brings us to item 16, House Bill 914 by Chair Lady Littleton. Got a motion and second. I'm looking at House Amendment 4746, ma'am.
That's correct.
Is that something you'd like to put on? I got a motion, got a second. Members, we're going to go ahead and adopt that amendment. Any objection to that? Seeing none, looks like we're ready to adopt House Amendment 4746 to House Bill 914. All in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on a bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. This authorizes the court to require as a condition of allowing a child to remain with the parents or guardian when the child is under the age of 3 and has been found to be dependent and neglected and diagnosed with neonatal abstinence syndrome. Submission of documentation of to the Department of Children's Services of compliance with preventive pediatric care consistent with the periodically schedule of the American Academy of Pediatrics. until the child reaches 3 years of age and requires parents or guardians to submit to a drug testing at regular intervals at the parent or the guardian's expense.
And thank you for that explanation. Members, do we have any comments or questions for Chair Lady Littleton? Seeing none. We ready to vote? Any objection? Seeing none. Looks like we're voting to send House Bill 914 as amended to Finance. All those in favor say aye. Aye. Opposed, say no. Ayes have it. That brings item 17, House Bill 641 by Chair Lady Littleton.
Second.
You got a motion, you got a second. I see House Amendment 4917, ma'am.
That's correct.
Members, we have Amendment 4917. Got a motion, got a second. Do we want to go ahead and adopt that amendment to this bill? Any objection to that? Seeing none. All those in favor of adopting House Amendment 4917, House Bill 641, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. This bill requires the Department of Children's Services to conduct a home visit to determine whether a child will receive proper care and supervision in the home prior to notifying the court of its intention to place the child on home trial visits.
All right. Thank you for that explanation. Members, do we have any questions or comments for Chair Lady Littleton? Are we ready to vote? Any objection to voting? Seeing none. Looks like we're voting to send House Bill 641 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. To calendar and rules. That brings us to item 18, House Bill 551, also by Chair Lady Littleton. Got a motion and a second. And Madam Chair, I'm looking at House Amendment now 6775. Is that something you'd like to adopt?
Yes, please.
Very good. You got a motion and a second. Members, we want to go ahead and put this amendment on the bill? Looks like we do. Any objection to that? Seeing none. All those in favor of adopting House Amendment 6775 to House Bill 551, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're welcome to explain the.
Thank you, Mr. Chairman. And first, I'd like to say that we worked with Representative Bolso and the AOC to correct Section 8, number 2, and we changed it to from 6 months to 9 months and shall be overturned by a trial court. And then the rest of the bill is this, we call this the ominous adoption bill, which we think it's going to make it a lot easier for people, parents to adopt children and to make it easier for foster parents and easier to become a foster parent. So it adjusts the allowable expenses that can be paid for potential adoptive parent, requires courts to enter surrender order when all other conditions have been met, reducing surrender revocation periods when appropriate, add in rape offenses to the list of grounds of termination of parental rights, requires DCS to file a petition for termination of parental rights within a set period of time when case involves heinous circumstances, strengthens standards for punitive and biological father wishing to hold themselves out as the father of the child, prohibits adoptions from being overturned after a shorter period of time than currently in law, making it harder for parties to show up after everything has been settled, prioritizes the search for kinship placements, giving foster parents and other involved parties ability to be more involved in court proceedings, and requires DCS to accept outside home studies under certain circumstances. And all this was done with the goal of making adoption and being a foster parent faster, cheaper, and easier for Tennessee. We worked all summer and we're still working on these. And this is the ominous bill. It says a lot. And I think it'll help us all with adoptions and foster parents and making it a safer and better place for our children to live.
All right, thank you for that explanation. Members, any questions or comments for our sponsor? Question's been called. Any objection to the question? Seeing none, looks like you're ready to vote to send House Bill 551 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. And members, we had adopted previously an amendment last week as well as this one. So legal and last legal will go ahead and roll those into one. This new amendment rewrites the bill. So correct. Amendment 1. All right. Without objection. And that brings us to item 20, House Bill 987 by Representative Beck.
Thank you, Mr. Chair. I'm waiting on language from the AOC. So could we roll this for a week so I can get it in proper posture?
Members, any objection to that request? Any objection? Seeing none. House Bill 987, next week's calendar. All right. Item 21, House Bill 1393 by Representative Harris.
Motion.
So you got a motion and a second. Looks like we have House Amendment 4725.
That's correct.
You got a motion and a second on that. Members, we will go ahead and get that amendment on the bill. Any objection to that? Seeing none, all those in favor of adopting House Amendment 4725 to House Bill 1393, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. Sir, and you're probably recognized.
All right, thank you, Chairman. And so House Bill 1393 would require that the statement of responsibilities in the DCS permanency plan of a child who has been removed from the custody of the child's parent or guardian due in some way to a drug abuse by the parent or guardian, that they must require that the parent or guardian submit to drug testing and demonstrate that that the parent or guardian is able to maintain a drug-free lifestyle in order to provide a safe home for the child. Drug use and drug addiction is at an all-time high, and while it may be adequate to see a parent stop the use of drug addiction while the child is no longer in their care, it will be beneficial that we see that a parent can maintain not using drugs when the child is back in their care. And so this language and this amendment changed. All we did in this amendment was change one word from drug testing to a drug test in order to make sure that the fiscal note did decrease. So with that, I renew my motion.
And thank you for that explanation, Representative Harris. Members, do we have any questions for the sponsor? Any questions or comments? Representative Capley, you recognize, sir.
Thank you, Mr. Chairman. And to the sponsor, would it be on the parents to pay for these drug tests? Who's paying for the drug tests?
Representative Harris.
Yes, thank you. And so no, it would actually be part of the home trial visit plan that the DCS already has to do while the case is open. So all of this is stuff that will already be taken care of within that. So this will be through the DCS.
Okay. Representative Capley, any follow-up?
Thank you, Mr. Chairman.
Members, anyone else? Questions, comments? Representative Bricken, you recognize, sir.
Thank you, Mr. Chairman. Maybe a question, or I should know the answer, but the definition of drugs, is that defined somewhere? So, I mean, are they, I assume illegal drugs versus non-legal drugs? I mean, somewhere, is that specified?
Representative Harris, is that something you want to answer?
That would probably have to be a question I have to ask specifically from legal.
Okay. Members, any objection going out of session and recognizing one of our fine legal attorneys here? Without objection, we're out of session, and it looks like Ms. Ansonia's got the mic.
Elizabeth and Sonia, Legal Services. The bill states that it would be removal from their custody due in whole or in part to drug abuse, and that term is not defined. So it could be legal or illegal drugs, but it would have to be abuse of the drug. So just, I think, regular use of a prescription drug would not be considered abuse.
Any follow-up? Members, any other questions for legal while we're out of session? Representative Grills, you recognize, Chairman Grills, for the sponsor? Okay. Without objection, we'll go back in session. And Representative Grills, you recognize?
Thank you, Mr. Chairman. How many drug tests will have to be administered before he or she will be considered clean?
Thank you, sponsor. And so prior to the child going back to the parent, there is typically a drug test performed prior to that. This drug test is specifically for the end of the home visit. The courts usually set a period of time, if I'm not mistaken, for a home visit trial to be done with the parent. And so this would only allow, this is only for one single drug test at the very end.
Any follow-up, Chairman Gross?
So they wouldn't have to prove that they have a history, like a turned over leaf or anything. It would just be one clean drug test. Is that correct?
Mr. Harris?
That's correct. The initial intent of the bill was for it to be a drug test every single month for 6 months. But after speaking with and working with DCS on this legislation, that kind of gets into parental rights issues. And so while we have an open case, it's only for one.
Very good. And it's my understanding that this protection is not currently in place. So this is doing more than what is currently being done. Is that an accurate representation of the bill?
Yes, sponsor.
Okay.
Yes, Chairman.
Okay. Representative McCaffrey, you recognize.
Thank you, Mr. Chairman. This is my last question, and I'll hush. It's to the best of my knowledge that DCS already does this. So are we just making it a law? Is that what's happening, sponsor?
Representative Harris.
They don't already do this necessarily. This isn't more so done in the case prior to the child actually going back to the parent. It's done prior to, but not done while the parent has custody. So you may be able to be clean and do it without having the child in your custody, but life happens and you're like, okay, this child is, I'm feeling stressed out. And I want to start using drugs again while I have the child back in custody. And this will give us an opportunity to make sure that that child is not going back into a home where drugs are being abused again.
Representative Capley, any follow-up?
Thank you, Mr. Chairman.
Thank you. Members, any more comments or questions for Representative Harris? We ready to vote? Any objection? Seeing none, let's ready to vote. Send House Bill 1393 to Finance. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on.
Okay, members, I'm going to take the gavel from the chairman, and we are on item number 22, House Bill 1351. We have a motion and a second. All right, we have a motion saying, Chairman, you have an amendment.
I do. If we could go with 6873.
Got a motion and a second. Without objection, we're going to put 6873 on the bill. All those in favor say aye. Aye. Those opposed? Ayes have it. Chairman.
Thank you, Mr. Chair, Vice Chair. Members, what this does, this puts a statute of limitations. There currently is not one. With regards to our sheriffs, our elected sheriffs are required to have a bond in the instance that if one of their deputies may do something, get sued, and then the sheriff's required to have a bond to cover those expenses or damages or whatnot. Right now, there's currently no statute of limitations. The original amendment just removed that liability altogether, but with working with the Sheriff's Association and other folks, we thought it may be best just to move to a one-year statute of limitations, which is the same thing we have for our tort cases like car accidents and personal injury cases and things like that. So this is what this bill does.
Thank you, Chairman. You've heard the explanation. Any questions for the chairman? Questions been called. Without objection, we're going to vote on House Bill 1351 to go to Finance. All those in favor say aye.
Aye.
Those opposed? Ayes have it. Thank you, Chairman.
And thank you. And members, real quick, I don't think I'm forgetting anything. Courtney, any announcements? Seeing none, I think we finished up the regular calendar. Just want to say real quick, is intended for next week to be our final calendar. I forgot to make that announcement on the House floor last week, so we're going to meet again next week. That's a good thing because there's some bills that need cleaning up a little bit, but it's intended for next week to be the final calendar, and I'll be making that announcement as well on the House floor in the morning. So without objection, you all ready to adjourn? Very good. Next week.